You would be surprised to know that most people don't lose their long-term disability claim because they aren't disabled. They lose it because they file too late, or too early, or without understanding how the actual timing works. Hi, I'm Brandon Osterbind, and I'm a disability lawyer here in Virginia. Before getting into today's video, if you find these videos helpful, please take a minute to subscribe to our channel and like this video. Now, I want to talk to you about when you should file for a long-term disability claim, because this isn't just a paperwork question. It's a strategy question, and getting it wrong can quietly cost you months or even years of benefits. The first thing you need to understand is this: there is no universal answer. Every long-term disability claim starts with one document, the policy. Most employer-provided long-term disability plans are governed by federal law under ERISA, the Employee Retirement Income Security Act, specifically 29 USC section 1132. But ERISA doesn't tell you when to file. The policy does. And the policy almost always requires you to identify something called your date of disability. That date is critical because every deadline that follows is calculated from it. Once the date of disability is established, most policies require you to provide notice of claim within a specific window. Sometimes that's 20 days, sometimes 30, sometimes 60. Miss that window and the insurance company may argue that your claim is untimely, even if you're legitimately disabled. After notice comes the elimination period. This is the waiting period where you're disabled, but you're not yet entitled to long-term disability benefits. Most commonly, that period is 90 days or 180 days, depending on the policy. The insurance company uses this time period kind of as a filter. They want to see whether your condition resolves or whether it truly prevents you from working long term. If you have short-term disability benefits, those usually apply first. You file for short-term disability as soon as your doctor confirms you cannot work. And during that short-term disability period, the clock on long-term disability is already running. And this is where people get tripped up. Many people assume that the long-term disability claim just happens automatically. Sometimes the insurance company will send forms near the end of the elimination period. Sometimes they won't. Sometimes the short-term disability insurance company is different altogether from your long-term disability insurance company. Either way, the responsibility is still yours. If your elimination period is 180 days, you generally need to be ready to file your long-term disability claim around the time that period ends, not months later. But filing at the right time isn't just about dates. It's about evidence. Your long-term disability claim should not look like your short-term disability claim. Short-term disability often focuses on a diagnosis and temporary restrictions. Long-term disability is different. At the long-term disability stage, the insurance company is evaluating whether you meet the policy's definition of disability, which is often tied with your own occupation and later any occupation. That means your claim should include updated and complete medical records, physicians' opinions that clearly address work limitations, functional restrictions, not just diagnoses, and in many cases, statements from people who can describe how your condition has actually changed your ability to work and function. This matters because under ERISA, the claim file you submit becomes the administrative record, and if the insurance company denies your claim, as many do, you typically only have 180 days to appeal that denial. That deadline is critical. Under ERISA, once the appeal period closes, you usually cannot add new evidence later, even if the case goes to court. In other words, the timing of your filing affects a lot of things. It affects whether your claim is considered at all, whether the right evidence is included, and whether you preserve your ability to challenge a denial. That's why filing too early can be just as dangerous as filing too late. File too early and the record may be thin. File too late and you may miss contractual deadlines written into the policy. So the takeaway is this: there is no safe default timeline. There is only the timeline that's created by your policy and how your medical evidence fits within it. If you're approaching the end of short-term disability, or if you've been out of work for several months, that's usually the point where long-term disability strategy becomes critical. If you're unsure about your date of disability, your elimination period, or your filing deadlines, that is not something to guess about. Those are decisions that shape the entire claim. If you need help reviewing your policy or mapping out the right timing, give us a call. This is what we do. We help people avoid mistakes that can't be fixed later. If you found this video helpful, take just a second and click that subscribe button and like this video for me. And before you go, make sure you watch the next video in this series, Social Security Disability versus Long-Term Disability. They're not the same. It explains how these two systems interact and why confusing them often leads to denied claims and reduced benefits.